Case?
Yes, that's right. Morning, I'm Greg Horowitz, represent the Shakiras regarding their residential home in Charlotte County, Florida. Yeah, it's a unique, novel issue, standing at inception. I know you have never ruled on that before, so you're in for a treat. Your Honors, there's two bases for the, we believe, to reverse the trial court's final judgment in favor of the bank. And that is what I've stated, and also there's no competent substantial evidence that the paragraph 22 letter was actually sent. The case was filed back, if you could believe it, July 13th of 2007. The complaint had a note attached to it made payable to First Franklin, a division of National City Bank of Indiana, and it did not show an endorsement. It's also important to know that the trial exhibits evidence shows that there was an assignment from MERS to another Deutsche Bank Trust, not the plaintiff in this case, and that was dated April 4th, 2007, which is just 3 months before this complaint was filed. And then what happened in this case is 7 months after the lawsuit was filed, they filed a note with two endorsements. First Franklin, a division of National City Bank of Indiana, to First Franklin Financial Corp., and then a second endorsement to First Franklin Financial Corp. to blank. So at some point in time, the plaintiff gained standing, but no proof of that it had standing at the inception of the case. They filed a backdated assignment, and that's what they're hanging their hat on in this case. It was filed, I believe, 3.5 months after the suit was filed, and it's dated October 31st of 2007, and it's backdated to 8 days prior to the suit.
So let me ask you a question.
Yeah.
So what's the effect during the course of the trial in this case of the court taking judicial notice, whole list of documents, without objection?
Judicial notice? I didn't object to any of their exhibits. I don't believe.
I don't think you did.
No.
They didn't prove what they needed to prove.
Right. They took judicial notice of the mortgage and the note, I believe, and that was because that was in the file, but that was about it. We went with what they had, and in the Vidal case in particular, it was a summary judgment case, but it still is the same law. It stands for the precedent that if you have a backdated endorsement, you have to put on evidence. That case talks about an affidavit. This would be at trial, showing that there was some type of equitable transfer prior to the case. And if you don't do that, you haven't met your burden to show standing. And that's where it was at trial. They never did prove it. I asked the...
Well, did you allege an affirmative defense of standing?
No, Your Honor, that's not necessary in the foreclosure cases.
Well, in the Vidal case, they did, and that was a summary judgment case.
Right, Your Honor.
But you didn't allege it here.
No, once you.
Wasn't that waived?
No.
Why not?
Because it's a negotiable instrument. It's part of their prima facie case, and the case law back going 30, 40 years. I've cited all the cases in my brief, and the recent cases spoken about in the May case, and other cases this morning prior. It's solid Florida law that it's part of their prima facie case in a foreclosure to show once you deny that they own and held the note, that's part of their case. They have to prove it. And I'm not going to list all the cases for you. They're in my brief. There's no case that says the opposite that I'm aware of. So no, we didn't waive it. You don't have to plead it in a foreclosure case. That's part of their case. We denied it, and that's enough. They had to prove it. Now, it's important to note that the Select Portfolio Servicing was the witness who appeared at trial. And the record shows that they came on, took over for the prior servicer let's see. Sorry. I believe it was 7 months after the lawsuit was filed. Yes, on 2/25/08, I believe, or thereabout, but it was definitely after. So it's important to note that, because when I asked the witness, do you have any documents to show that your predecessor held a note at the time the suit was filed? No. There's nothing besides the complaint. Do you know when the endorsements were on the note? No. So they're relying on this assignment that was backdated, and I asked him, can you tell us the circumstances surrounding this backdated assignment? And he says, besides what the assignment says, I don't know. There's a complete failure to show standing in this case, and the judgment should be reversed on that ground in accordance with the Vidal case. I think it's right on point. And the second issue is the acceleration letter. Select Portfolio, the witness from Select Portfolio had never worked for First Franklin, the previous servicer. He didn't know their normal business practices. Under the evidence code, they could have proven the normal business practices to prove mailing. They could have had a mailing log, some evidence. But in this case, the witness, they didn't subpoena the witness from the first servicer to testify that about those issues. The letter is a computer-generated letter. It's not even a real copy of the letter if you take a look at the evidence. And the witness, actually the judge found in the contact log a entry that says breach, C-SIM for copy, LETCOL, and it says 5807 NLR BR 999001. And the judge thought that was proof that it was mailed. And Your Honors, the witness had no idea what the numbers meant. He thought LET meant letter. It does reference breach, C-SIM for copy. And we know there was a letter in their computer, but you can't jump to the conclusion that it was mailed based on this. So on those two grounds, I would ask the court to reverse the judgment and dismiss the case for failure to prove by competent and substantial evidence that the letter was mailed, and also that they didn't have standing on the date the complaint was filed. There's nothing there.
Thank you. Thank you, Mr. Hall.
Good morning. May it please the court. Will Grimsley on behalf of the appellee, U.S. Bank, as trustee for the subject trust. This is an appeal of a final judgment of foreclosure. This is not a summary judgment case. A bench trial was had to resolve all disputed issues of fact. If there was a piece of evidence that lended itself to multiple inferences, it was a trial judge's job as the trier of fact to resolve those issues, to choose what inference should be had in the case after weighing the testimony, judging the evidence. At trial, the bank introduced 10 exhibits, all of which were admitted without objection. The witness from Select Portfolio testified on the plaintiff's behalf as the servicer of the loan. There was his testimony. There were certain objections raised by appellants, some of which were sustained, some of which were overruled, none of which is at issue here today. It's only the sufficiency of the evidence. On the issue of standing, to your point, Your Honor, the bank submits that this issue was not preserved for appeal because the Fidel case, which is a foreclosure case, states that that standing is affirmative defense that must be raised, otherwise it's waived. Now, a simple denial of the fact that the plaintiff is the owner and holder of the note and mortgage, which is what is alleged in paragraph 4 of this case, isn't sufficient to preserve it as an affirmative defense.
You still have to prove it.
Correct, Your Honor.
Other than arguing that this was backdated. How does this assignment of mortgage, it says for value received July 5th, 2007, which would have been a few days before the complaints filed? Is that what you're relying on to show that you held and possessed the note and had the right to foreclose prior to instituting suit?
Prior to, at the inception of the case, the witness at trial specifically stated he was basing his testimony on the endorsement in blank, which the testimony reflected and the judge observed that the endorsement was actually on the back of the note, which offers a plausible explanation as to why it was not reflected on the copy attached to the complaint, but also the assignment of mortgage, the second assignment. There were two assignments. The first and the second one is critical to this court's analysis because the assignment assigned both the mortgage and the note. This wasn't just a simple assignment of the mortgage. So it demonstrated that there was an equitable transfer of the note as well as the mortgage June 5th or before 2007, which was prior to the filing of the complaint. Now, appellants rely exclusively on the Vidal case, which was a summary judgment case. And in that case, the court struggled with, well, we're at summary judgment, and there are two inferences that could be had from an assignment that has an effective date prior to the filing of the complaint, but was executed after the complaint was filed. Now, at summary judgment, it may not be proper for the judge to make that inference, because as appellants concede in the initial brief, page 17, two inferences, one of which could be that there was the equitable transfer, the other which could be that the note or the assignment was dated at a date prior to the complaint simply to benefit the plaintiff in that action. The judge looked at all the evidence. The judge expressly stated, after looking at the assignment itself, and this is on page 720 of the record, that's the trial transcript, at line 25, continuing on to page 721. The court agrees that the assignment transferred the note prior to the filing of the complaint, and that the assignment says it was transferred on 7/5/2007. So the judge is looking at that. The judge is making that inference. The judge is saying, I see this, and under McLean, a case dealing significantly with conditions precedent, if you're relying exclusively on an endorsement, you must show when that endorsement occurred. Now, if you can show or demonstrate an equitable transfer through some other means, in this case, the assignment of the note and the mortgage, it doesn't matter whether the assignment was executed after the complaint was filed. What's critical is that the assignment memorialized a transaction that occurred at a date prior to the filing of the complaint. Now, there was no evidence to the contrary. There was no evidence that rebutted the transfer of the loan to the bank at a date prior to the filing of the complaint. And the judge, with everything it had before it, drew that reasonable conclusion that, in fact, the assignment conveyed the note and the mortgage prior to the filing of the complaint. The witness testified that based on the note, the mortgage, the two assignments of mortgage, that the bank was the holder of the note at the time the complaint was filed. Addressing the second issue, the bank introduced the default letter and the contact history into evidence in support of demonstrating satisfaction of conditions precedent. These were admitted without objection. So we're not dealing with admissibility here. Admittedly, these are records that were the prior servicer's records. Now, the witness, Select Portfolio's witness, testified as to SPS's or Select Portfolio's procedures, their boarding procedures for vetting the information it gets from prior servicers to determine the accuracy of the documents it receives, and then those documents are incorporated into Select Portfolio's system, and it becomes their business records. Now, admissibility here is not at issue, but under WAMCO and under the 4th DCA's recent holding in Callaway, that passes muster that basically those records are the records of Select Portfolio, the current servicer. Now, looking at what the court had before it, it had a default letter that was generated on May 8th, 2007. Now, the witness testified that when that default letter was incorporated into SPS's records, it was determined to see if it was accurate. If it was not accurate, the loan would have not been boarded by Select Portfolio. What did they do to verify? One of the steps was we look at the letter, we match up the loan number, the address, to see if it matches what is in Select Portfolio's system. That happened here. The witness testified he checked. That they matched up. There was nothing in the system that indicated the letter was not sent. The second piece of evidence, the contact history. Now, at trial was, well, there's a P.O. box to which this letter was sent. It wasn't the property address, and under paragraph 15 of the mortgage, notices go to the property address unless the borrower contacts the bank and says, I'm changing my address. Now, the contact history, and this is on page 649 of the record. The borrowers called in and said, address change, P.O. box, and it gave the P.O. box. That P.O. box, which is notated on the contact history, matches what was on the default letter. And this was in 2006. Lydia Shakira got on the stand and said, I had the P.O. box in 2006. I changed it at some point, or I canceled it at some point, maybe 2007, but in 2006, I had that P.O. box. So the evidence, the default letter itself, the contact history, which through the testimony of the witness were SPS's records, although generated by a prior servicer, demonstrated that to the judge's satisfaction that the letter had been sent. Now, the judge's ruling at trial on this particular issue, he observed that the note was only signed by Mr. Shakira, that the default letter was only addressed to Mrs. Shakira, Lydia, that both parties were on the mortgage, and that the mortgage requires a default letter. The note doesn't require a default letter. So under paragraph 15, as the judge said, we're governed by 15 here. Notice to one borrower is notice to all borrowers. So the judge said, I find that there is sufficient proof, that's the default letter, the mortgage which provides the method in which it should be provided, and the contact history, sufficient proof that the default letter was sent. It doesn't have to be clear and convincing. What you're looking for here is competent, substantial evidence. Now, there was testimony. There was testimony that from the borrower that Mr. Shakira said, I didn't receive this letter. But that alone isn't enough to overcome the evidence that showed the letter was generated and the contact history, which showed breach, provided the date, a strong indication that the letter was sent. So on balance, the judge, weighing the testimony, weighing the evidence, the judge said there is sufficient proof here. If there are further questions from the bench. Because the bank established standing through the blank endorsement, the assignment of the note and the mortgage, which occurred at a date prior to the filing of the complaint, standing was established in this case. Because the default letter and the contact history and the testimony of the witness demonstrated to the judge's satisfaction, competent, substantial evidence, again, that the default letter was generated and sent, the bank would request that this court affirm the final judgment below.
Thank you, Mr. Grimsley. Mr. Horowitz.
Thank you, Your Honor. The Vidal case says that we can't have backdated assignments, and it says in footnote 1, allowing assignments to be retroactively effective would be inimical, contrary, I had to look it up, to the requirements of pre-suit ownership for standing in foreclosure cases. It was a summary judgment case, but it still sets the standard for backdated assignments. You have to give, they said, an affidavit for purposes of summary judgment, but testimony explaining that it's not, this is not, the assignment is not testimony sufficient to overcome the fact that the assignment's backdated. You have to put on testimony to show that an equitable assignment or a transfer took place. This witness didn't know who held the note on the date the case was filed. didn't know the circumstances surrounding the assignment, and they have an extra burden if you're going to backdate an assignment dated 3.5 months before the suit was filed. You have to show some kind of a transfer occurred, and this witness didn't know when his predecessor came in possession of the original note, when the endorsements were put on. And as far as the proving mailing, I'll leave it up to the court. If you determine that this line in the contact sheet proves that it was mailed, I'll leave that up to you, but I don't see it. I don't see it in any way. The witness didn't. He said, based on looking at this, the letter was mailed after the judge pointed it out to him, but this is not, it doesn't say anything about mailing, so I don't believe that they've proven by substantial competent evidence that the letter was mailed. And in fact, my client testified that she never received the letter. We would ask on jurisdictional grounds that they didn't prove that they had standing at inception, and also that they didn't comply with the condition preceding. They didn't prove that the letter was mailed. Thank you.
Okay.